Hi guys, welcome to another lesson in Federal Civil Procedure. In this lesson, we're going to cover permissive and compulsory joinder of parties. Specifically, I'm going to cover Rule 19, joinder of parties, persons required to be joined if feasible, and Rule 20, permissive joinder of parties. I'm going to begin with Rule 20 because I think it's going to flow better in the lecture. So let's begin. Joinder of parties, Rule 20, permissive joinder. I think the best way to explain Rule 20, permissive joinder, is to give you an example. So I'm going to start with a scenario with a fact pattern, and then we're going to discuss the rule. Here are the players. Super Concerts is an event creating company. They conduct events. They solicit and hire singer-performer Brianna for a series of concerts. Super Concerts also contracts a stage company, Stages, to set up the stage and infrastructure needed for the event, and a security company, Sedentary Ninjas, to take care of the security for the concerts. So let's say Brianna is performing on stage. The stage feels already a little wobbly. There are lots of people in the crowd, maybe even too many people. In addition to this, the rapper Cheesy, envious of Brianna's success, gets through security somehow. He cons his way into the event with his golf cart and drives the golf cart right into the crowd, right into the stage. The stage falls apart, injuring concert goers, security personnel, as well as Brianna, who, due to her injuries, is now unable to perform on the rest of her contract with Super Concerts. So she has to cancel the remaining of her concert tour. Fans are devastated and people are injured. From a legal standpoint, how can this play out in court? Now, just a note, for this example, we don't really care about going into a rabbit hole of torts and contract liabilities. We will be focusing on the rules of litigation. Brianna could sue Super Concerts, Inc. for negligence, maybe as them being vicariously liable for what happened with Stages. Brianna could also sue Cheesy. There are several scenarios that are feasible. For example, Super Concerts can sue Cheesy, Sedentary Ninjas can sue Cheesy individually as well. Maybe even Stages can sue Cheesy. Super Concerts can also sue Sedentary Ninjas because they're the ones that let Cheesy in, right? I'm talking about individual lawsuits. But with Rule 20, we're talking about joinder. So my first question is, can Brianna join with another plaintiff, like, for example, Sedentary Ninjas, to sue Super Concerts? Can the patrons, the people, the concert goers, also join as plaintiffs together with Brianna and Sedentary Ninjas to sue Super Concerts? So the initial joinder of plaintiffs, and remember this part, the initial joinder of plaintiffs is governed by Federal Rule of Civil Procedure 20A1. Permissive joinder under 20A1 authorizes plaintiffs to sue together if they each assert claims arising out of the same transaction or occurrence, or series of transactions and occurrences, and their claims against the defendant will involve a question of law or fact common to all parties. So yes, it looks like under Rule 20A1, Brianna, Sedentary Ninjas, and the patrons, the concert goers, can join together as plaintiffs to sue Super Concerts because they're each asserting claims arising out of the same transaction, the same occurrences, and their claims against the defendant will involve a question of law or fact that is common to all parties. They're all suing on that same event. Their claims arise from the same event. And the recovery of all the plaintiffs here hinges on whether Super Concert was negligent, whether Super Concerts is liable. So there's a question of law and fact common to all parties. The next question is, can defendants be joined? Let's say that Brianna wants to join with Sedentary Ninjas and the concert goers to sue Super Concerts and Stages. That's where Federal Civil Procedure 20A2 comes in, and it allows the plaintiffs to sue multiple defendants in a single action if the same criteria are met. Let's look at it. Permissive joinder of defendants. Federal Rules of Procedure 28-2, parties may be joined as defendants if each plaintiff asserts claims against each defendant arising out of the same transaction or occurrence or same transactions or occurrences, and each claim against the defendants will involve a question of law or fact common to all parties. Same as 20A1, except we're dealing with defendants. So back to the question of how can this play out in court? Well, we can have a single plaintiff sue a single defendant. We can have multiple plaintiffs join together to sue a single defendant under Rule 20A1. We can also have a single plaintiff join several defendants under Rule 20A2. And we can also mix them together. We can have several plaintiffs join together as plaintiffs and sue multiple defendants, join multiple defendants under Rule 20A1 mixed together with Rule 20A2. Now, before we move on to the next topic, let me give you 2 quick scenarios I've seen on exams and that have thrown off some students. Let's say that Brianna and Sedentary Ninjas join as plaintiffs, but they seek recovery for different injuries under different causes of action. Same event, but they have different causes of action. Brianna is suing under breach of contract, and Sedentary Ninjas is suing for negligence. Can they join together as plaintiffs? And the answer is yes, so long as the criteria is met. Rule 20A1 does not require that plaintiffs seek recovery for the exact same injuries or on a joint interest. It only requires that the underlying transaction or occurrence be the same, and that the plaintiff's claims share a common question of law or fact. Almost done with permissive joinder. There are a couple things that I want you to keep in mind with Rule 20. First, Rule 20 only applies to joinder of parties by the original plaintiffs. Original plaintiffs joining together as plaintiffs or original plaintiffs joining defendants. The difference is going to matter later with supplemental jurisdiction, and I just want you to remember that this applies to original plaintiffs. The next thing I want you to keep in mind is that the purpose of Rule 20 is judicial efficiency and outcome consistency. If the conditions in Rule 20 are met, it's very logical to allow parties to join together as plaintiffs or to sue defendants jointly in a single lawsuit. When several claims involve the same transaction, the same occurrences, and the same issues of fact and/or law will have to be litigated to resolve each claim, it is much more efficient, much more useful to resolve those issues in a combined action, in a combined lawsuit, rather than separately in different lawsuits. Resolving these matters in a single action also avoids the possibility of inconsistent outcomes of the same issues and lends itself to a more uniform, economical process for all involved. Next, and this is an important one, Rule 20A does not require joinder. It does not require parties to join whenever the criteria in the rule is met. At the onset of a lawsuit, at least at the very beginning, the joinder decision under Rule 20 is left to the plaintiffs. They can choose to sue together with other plaintiffs and/or sue multiple defendants in the same action. There is a rule, however, that requires joinder of parties, so this is a perfect segue to what I will be discussing next. Let's talk about required joinder of parties under Rule 19, also called compulsory joinder or mandatory joinder of parties, and it provides for the joinder of necessary parties. Under Federal Rule of Civil Procedure 19, in certain situations, certain persons or entities not initially a party to the lawsuit may be required by the court to be joined in the lawsuit, or the lawsuit may face the possibility of dismissal. These are people or entities that are deemed to be indispensable to the lawsuit in order for the court to fairly adjudicate, to fairly decide the case. But before we dive in, I want to mention 2 quick things about required joinder of indispensable parties. 1, I see this stated erroneously in a lot of online review courses, so I want to clarify. While necessary parties are typically joined as defendants, they're brought into the lawsuit as defendants, the court may also join them as involuntary plaintiffs. So it's not the case that Rule 19 is only the joinder of parties as defendants. Also, although usually original defendants are the ones that file a motion for an indispensable party to be joined, the court can act sua sponte, meaning the court can take notice of this issue in its own motion without prompting or suggestion from either party. This means that the court can itself bring up the issue. Usually the parties are the ones that bring up the issue. Your Honor, there's an issue here. But in this case, the court can actually bring up the issue on its own accord. So this is a form of compulsory joinder because it's somewhat mandatory. Remember earlier when I said that at the onset of a lawsuit, at least at the very beginning, the joinder decision under Rule 20 is left to the plaintiffs. Well, here, this is the court essentially restructuring the plaintiff's case in the interest of justice. So, compulsory joinder of parties is the process of requiring parties without which the suit could not proceed to be joined to a single lawsuit if feasible. Now, I want to make sure that you go online or to your book and save and read the official version of the rule verbatim. This chart on the screen is the rule for compulsory joinder of parties reconfigured to fit into a flow chart of the analysis. I want to go through this chart step by step, so I'm going to move my screen to my iPad so we can go over each of these. Let's begin with the first part of the analysis, and I can't emphasize this enough. For those of you in law school, if your professor tells you how she wants the analysis, do whatever your professor says. Otherwise, this is how the analysis goes according to yours truly. First question to ask is, should the absentee party be joined? It's a very logical first question, right? And the answer will be yes if any of the following apply. I want to note here that these are not conjunctive elements. Not all of these should be met. The rule is that if any of these are true, then the absentee party should be joined according to the law. And the answer to the first question would be yes. The first scenario where it can be determined whether the absentee party should be joined is where the court could not offer proper redress of the issues, proper relief to the parties who are already before the court, who are already part of the lawsuit. Okay, let's look at an example of this. Let's say Brianna enters into a single contract with both Superconcerts and Sedentary Ninjas. These two businesses told her they would work conjunctively to manage the concerts and the security needs for the events. At a future date, Brianna notices Superconcerts and Sedentary Ninjas had misrepresented their capability to handle these events, and they also lied through their teeth in order to get her to sign the contract with them. So she brings an action against Superconcerts to rescind the contract, which, by the way, is not the same as breach of contract. To rescind a contract means to cancel the contract, to make it null and void, to essentially turn back the hands of time and make it so that it never happened. Okay, so she sues Superconcerts to rescind the contract, but she does not sue Sedentary Ninjas. If we analyze this just a little, you're going to notice that complete relief cannot be accorded to Brianna unless Sedentary Ninjas, the security company, is joined as a defendant. And why is this? Well, if the court were to grant Brianna her request to rescind the contract, to cancel the contract, the court's order would rescind the contract as to Superconcerts, but not Sedentary Ninjas. Sedentary Ninjas isn't part of the suit, so a court order would not apply to them. And remember, if any of these three apply, you should conclude that the absentee party should be joined. So this determination here answers the first question of whether Sedentary Ninjas, the absentee party, should be joined. And the answer is yes. Sedentary Ninjas should be joined as a party. This is true even if the other two don't apply, because these are not conjunctive elements. If any of these is the case, the answer is yes to the question of whether the absentee party should be joined. Now, the next situation where an absentee party should be joined is when not joining absentee party would impair or impede her ability to protect her interest in the subject matter being litigated. This here addresses a situation in which a court order would potentially have a collateral impact on the absentee party. even if the absentee party is not directly subject to the court order. How come? Well, sometimes a court order has an unintended effect on people not party to the case. Here is an example of this one. Rapper Cheesy and Brianna allegedly both buy stock in Stages Inc., but the shares are issued and held in Cheesy's name only. Sometime in the future, Cheesy wants to sell the stock to pay off some gambling debt. So Brianna sues the company that issued the stock, Stages Inc., asking it to reissue the stock, but in both their names. In both the names of Brianna and Cheesy, since the stock was allegedly purchased by both of them. In this situation, if the court determines that the stock is indeed jointly owned by both Cheesy and Brianna, then in order directing the company Stages Inc. to reissue the stock jointly would absolutely affect Cheesy's interest if he does not participate in the adjudication of the case, if he does not participate in the lawsuit. Cheesy here is an absentee party whose interest in the subject matter of the dispute would be impaired if he didn't participate in the lawsuit. So if there's a situation like this, then the answer to the question, should the absentee party be joined, is going to be yes. All right, next. Third scenario where the answer to whether a party should be joined is yes is when deciding a case without the absentee party would leave any other party in the suit at a substantial risk of incurring multiple or inconsistent obligations. This one is arguably the most complex of the three. Let's look at an example. Stages Inc. sells land to Super Concerts Inc. But per their agreement, an escrow company is instructed to withhold $50,000 of that money until Super Concerts completes some improvements the parties agreed on would be done by a certain date. The date arrives and Stages Inc. sues the escrow company to release the $50,000. However, Super Concerts maintains that the improvements agreed upon are not up to par. So they oppose the release of the money, but they're not a party to the lawsuit. Stages only sues the escrow company. Now, if the court in Stages' lawsuit orders the escrow company to release the fund to Stages, the escrow company is left open to the possibility of a second lawsuit against it by Super Concerts, who disagrees the improvements are up to par for the funds to be released. The court's order would subject the escrow company, a party already in the suit, to inconsistent obligations, to potential for inconsistent obligations. So in a situation like this, we answer yes to the question, should the absentee party be joined? Now, if none of these apply, then you do not need to worry about compulsory joinder. No compulsory joinder issue if none of the above apply. However, if you answered yes to this first question, because one of these scenarios applies, we move on to the second question. Is the court unable to join absentee? And the answer will be yes, the court is unable to join absentee if there are any jurisdictional impediments. This happens if the court lacks personal jurisdiction over the absentee party, also if joining the absentee party would destroy the court's subject matter jurisdiction over the case, and we usually see this in diversity cases. Let's say the court has federal subject matter jurisdiction based on diversity of citizenship, and joining the absentee party would defeat diversity. That would destroy the court's ability to preside over that case. Another scenario is if venue would be improper if the absentee party is joined. Then the court's unable to join the absentee party even if this party is indeed indispensable, even if we determine in the previous step that the party should be joined. I'll give you a few examples. Brianna, a citizen of California, sues Super Concerts, a Delaware corporation, in federal court. And there's diversity of citizenship and the amount of controversy is met. Let's say that we have already determined that Stages Inc. is a necessary party, a party that should be joined. But Stages Inc. is a California corporation with principal place of business in California. Joining Stages as a defendant would defeat diversity. No defendant can be from any state as the plaintiff. This would destroy the federal court's subject matter jurisdiction over the matter because, in this case, subject matter jurisdiction is based on diversity of citizenship. Another example, let's say Brianna sues Superconcerts in Delaware court. Obviously, the court has personal jurisdiction over Superconcerts because Superconcerts is a Delaware corporation. But let's say it does not have personal jurisdiction over Stages, a California corporation. Then Stages Inc. can't be joined. The Delaware court has no power over Stages. It has no personal jurisdiction over the absentee party. So this highlights how important subject matter jurisdiction, personal jurisdiction, and proper venue are. Even if it's determined that the absentee party should be joined, they cannot be joined due to jurisdictional issues, jurisdictional impediments, so they will not be joined. Now, if we've determined in the previous step that the absentee party should be joined, and there are no jurisdictional impediments, then the party must be joined. Must be joined. But if there are jurisdictional impediments and the court is unable to join the absentee party, then we move on to the next step, to part 3 of this fun little odyssey. And if we are here in this question, we know the absentee party should be joined, but cannot be joined due to jurisdictional impediments. So now the question becomes, should the court allow the lawsuit to proceed without the absentee party, or should the case be dismissed? And the way to answer this question, unfortunately, won't be black and white. There is no bright line rule. The jurisprudence on the matter has developed criteria, which has been later codified, and these are factors to consider and weigh. The following analysis of whether to proceed without absentee party or dismiss the case is called analysis of equity and good conscience under Rule 19. Let's go over the factors together. The first one to consider is the extent of prejudice to both the absentee party and parties already before the court. So here we're looking at the amount of the prejudice. Is it very prejudicial or just a little bit? Next, we're going to look at the extent to which protective provisions in the final judgment may be used to sidestep or to reduce the prejudice to the absent party. What this means is that the court is evaluating whether it has the ability to craft the judgment in such a way so as to sidestep or minimize the prejudice on the parties or the absentee party. Third, we're going to consider whether the decision rendered by the court without the absentee party will be sufficiently adequate to the parties already before the court. And lastly, whether the plaintiff will have the ability to obtain relief in another forum, in another court, if the lawsuit is dismissed due to the absent party. So in these scenarios, the court has guided discretion because the drafters of Rule 19 recognize that every case is distinctive, and a bright line rule would be inadequate as a catch-all in these scenarios. So after balancing this criteria, decide the case should be dismissed or litigate without the absentee party. And if the court is litigating without the absentee party, then it should probably want to shape the judgment to give proper relief to the parties despite not joining the absentee party. Alright guys, that is it for compulsory joinder of parties. Here is the little roadmap that I showed you earlier, the one that we went through step by step. You can take a picture of it or you can go to my website and download it. That's it for joinder of parties, required joinder, and permissive joinder. I really hope this video was valuable to you. If it was valuable, please give it a like and subscribe. And if this is how you're feeling after this lecture, email me at questions@jdsimplified.com.